Hello, everyone. Just going to give it a minute here to let some folks trickle in. All right, so we'll get started. So it's 1 o'clock. Welcome to the Division of Real Estate, Colorado HOA Information and Resource Center's presentation on rental restrictions in your community. My name is Nick Altmann. I'm the HOA officer here at the center. I'm also very excited to have with me today David Donnelly, our manager of communication and education policy, and also Amanda Lopez, our registration specialist. Hope everybody was able to come out of the thaw that we had from the freezing temperature we had yesterday. That was not very pleasant, but anyway, glad everyone's here. So just a quick disclaimer. The information provided during this presentation is for educational purposes only and is not meant to provide, nor should it be construed as legal advice. Any legal questions should be directed to a qualified attorney licensed in Colorado. Making sure I'm not on mute. So I always feel this is important just to remind everyone what we do and what we don't do. The HOA Information and Resource Center provides information to homeowners regarding their basic rights and responsibilities under the Colorado Common Interest Ownership Act, which is pronounced CCIOA sometimes. We gather, analyze, and report information through complaints and HOA registrations. We create resource materials and put on educational forums just like this. And we also provide an annual report to the state legislature. What we don't do, importantly, is we're not a regulatory program. We don't arbitrate. For purposes of this presentation, we can't regulate your HOA's inability to enforce rental restrictions, for example. We can't arbitrate between two homeowners who might be arguing over a short-term renter's violation of the HOA rules. We are specifically not for or against short-term rentals in general. This is just meant as an educational forum. And we also can't regulate your HOA's, for example, inability to enforce rental restrictions. And today's presentation is intended for tenants, homeowners, board members, and community association managers, so everyone, or no one's excluded. I think we have a poll here we're going to try and get. Just curious to see who's joining us today. You should have a poll on your screen if you want to go ahead and answer that real quick. The question is, who are you? Tenant, homeowner, board member, or community association manager? And it seems like we have quite a lot of board members and homeowners as well, and also some managers. So that's awesome. I think the results should be shared. You should be able to see that, but that's great. Great news. Okay. All right, so no matter who you are, you can be a homeowner or board member, understanding your rental restrictions in your community is an important first step. You might be considering buying into an HOA, and it's a very important thing to know what you're getting yourself into, to know what those restrictions are, if there are any. And also, you might be an investor. You might be thinking about investing in a certain property. Maybe you don't necessarily want to live there, but if you want to invest in that community, it's important for you to know what any of those restrictions might be. Short-term rental or long-term rental restrictions. see here. So just to start off with a couple definitions, a short-term rental is a lease for residential property, which is typically furnished and is available to be rented for a short period of time. There's no universally agreed upon duration for a short-term rental. A landlord is a person or a company who rents land, a building, or an apartment to a tenant. The lease agreement is a contract between a landlord and tenant outlining the terms for the rental of property. A long-term rental is traditionally a period of a lease that could be greater than 30 days or a year or two. And a tenant is a person or company who occupies land or property rented from a landlord. Long-term rental is presumed to be over 30 days. So the Division of Real Estate, we've developed a position statement on behalf of the Real Estate Commission that's meant to be just advice, not a rule or law. Commission, just for your reference, Commission Position 12 on short-term rentals means a short-term rental is typically a furnished residential property, example, an apartment, a townhome, a condo, or a house that's suitable or intended for occupancy for dwelling, sleeping, and lodging purposes, and is available to be rented for a short period of time. A short-term rental is considered an alternative to a hotel where the guest may feel more at home. Taxes are generally collected from guests for rental periods of 30 days or less. While taxing authorities consider rental periods of 30 days or less as short-term rentals, stays longer than 30 days are not automatically considered a lease. And there's a link there if you'd like to read that position statement again. And I think we have another poll here that we can get launched. Does your community have rentals currently? Wow, a lot of yes, a lot of yes. Seems like most HOAs are allowing rentals, so it's interesting. See if I can get the next slide here. As you're talking with your community and trying to figure out whether you want to enforce restrictions on rentals, a couple things to consider, like why would you want to restrict rentals? Maybe you want to safeguard your property values. Maybe you want to ensure the safety of your community or reduce crime. You might want to control HOA insurance costs. That's always an ongoing concern, and how expensive insurance is getting, especially those deductibles. By that, I mean, the more renters that your community sees, the more people coming in and out and using your HOA amenities, that creates more reliability concern and greater and increased costs on those insurance costs, premiums. Lenders might be more hesitant to extend loans in neighborhoods with high short-term rental rates. And then finally, another reason might be maybe you just want to preserve the way your community feel. You might live in a mountain town and maybe you just want to preserve the natural surroundings, or you feel passionate about what your community means to you and what it should mean to tourists and outsiders, and that might just be something that your community would want. So our favorite law that we all love, CCIOA, what does it have to say about covenants and use restrictions? This is the definition straight from the Act, and it's section 3833.3-2051L. If you're interested in reading it, it says the declaration must contain any restrictions on the use, occupancy, and alienation of the units, and on the amount for which a unit may be sold, or on the amount that may be received by a unit owner on sale, condemnation, or casualty loss to the unit or to the common interest community, or on termination of the common interest community. So what does that mean exactly? Succinctly speaking, it must be defined in your declaration, any restrictions on the use or occupancy of your unit. So what do your governing documents say about rentals? Have you had a chance to read through your declaration, any rules and regulations that you might have that could restrict rentals? Are your governing documents silent? Maybe there is nothing in there and you're just trying to get some advice or some direction on what's put in there. In that case, it would be best to consult a qualified Colorado attorney, but to help with amending your documents. But absent specific authorization in the declaration, an association does not have the power to adopt rules that restrict the use or occupancy of individually owned units. Those changes have to be done in the declaration, which typically, or most of the time, will require a full community input, community votes. Another important section in CCIOA here, section 217, 4.5. Except to the extent expressly permitted or required by other provisions of this article, no amendment may change the uses to which any unit is restricted in the absence of a vote or agreement of unit owners, which I just mentioned, to which at least 67% of the votes in the association are allocated, or any larger percentage the declaration specifies. The declaration may specify a smaller percentage only if all of the units are restricted exclusively to non-residential use, which is relatively rare. But it does require, an amendment to the declaration does require at least 67% of the votes. Here's a case I thought was interesting: Houston versus Wilson Mesa Ranch Homeowners Association, if you want to look that up. Basically, this case provided that for short-term rentals to be prohibited in an HOA, the covenants, conditions, and restrictions must be amended. And of course, you know, it does get a little tricky with House Bill 1137 and how the board, how they're allowed to issue notices of violation. But for this purposes, we're going to try and keep it rental restrictions in the community. Actually, I think David's joining us. He's gonna speak a little bit on FHA here.
Absolutely. Thanks, Nick. This has actually already come up in the chat, so I'm real excited about that. Thank you to Peter for bringing up the fact that FHA lending tends to be a little bit more complicated, if not even not allowed, in communities that have higher rental rates. So that's definitely something to keep in consideration. What we want to talk about when it comes to the Federal Housing Administration, that's FHA, is that board members really should carefully review all of their governing documents in order to determine if there are any specific or special insurance requirements. CCIOA itself does require that communities that have been created after July 1st of 1992, again, what we call post-CCIOA communities as opposed to pre-CCIOA communities, they are required to purchase and maintain insurance policies to the extent that insurance is reasonably available to them. And but the interchange here that takes place between insurance and lending is an important consideration. Again, it's outside of honestly the skill set of the HOA office, because this is based on federal laws, federal lending laws primarily through the FHA. However, board members should consult with counsel, whether that's a licensed Colorado attorney or their insurance broker, in order to better understand what some of those FHA requirements are specifically, because it can, there's a detrimental effect when if you have, think about it, if I'm trying to sell my unit and I've got a pool of 100 buyers, potential buyers, excuse me, or 20, because I can only get financing through, or my unit would only be able to be eligible for financing through certain programs, maybe private lenders, but probably not FHA or not VA loans. Those are some important considerations. So for board members to keep that in mind and be cognizant of what your rental rates are. And a little bit later in this in our presentation here, we're actually going to ask the question of you all, what do you suppose, what do you believe the percentages of rentals are in your communities? Hold off on your answer until we'll shoot a poll out in a little while. But that's definitely something that we want you all to keep in mind, board members in particular. How about the next slide there, Nick? And so a couple additional resources that I would encourage board members in particular, but homeowners and tenants alike to be cognizant of. These rules they're pertinent to just everyday activities, but particularly they are pertinent to the issues arising from long-term and or short-term rentals in your communities, and those arise from the Federal Fair Housing Act, as well as the Colorado Fair Housing Act. So, but what the next section that we're going to talk about when I hand this back over to Nick here is that there are a lot of local government housing protections, fair housing protections in place, and while clearly this forum cannot cover every county, every municipality in the state of Colorado, we are going to hit on a couple ones just to show you some of the variability and to encourage you to look to your local county ordinances. Look to your municipal ordinances if you're in an incorporated area such as Denver or Colorado Springs, and have a good understanding of what the protections are that are in place, and help educate your homeowners of that. So should they be looking to rent, that they're fully advised of what is necessary, both from a fair housing protection perspective, but also just a licensure and compliance perspective. And with that, Nick, I'll pass it back to you. Okay.
All right. Thank you, David. Excuse me. So, of course, David was just mentioning, a lot of the intricacies with FHA, and also your local municipality and town or city is also going to have their own codes or ordinances when it comes to rental restrictions. So you definitely want to take a look at those, as well as your HOA governing documents. But a couple considerations or a couple questions you might want to ask yourself here is, even if rentals are allowed in your community, how are they going to interact or with the local county code? So it's kind of interesting because for example, if your declaration say that it prohibits rentals, like it says no rentals allowed, the association may not allow rentals. That makes sense. So if the declaration allows for rentals or is silent on the matter, the HOA can still adopt policies and rules regarding rentals that will align with the county code or the town code. That's what I mean there by the floor. It may still adopt rules that comply with the floor of a local county ordinance. So that might be the case if your declaration is silent on the matter. So associations can have rules and regulations, but they cannot contradict laws. The law applies, but an association can require additional restrictions. I know it's lots of, it could be confusing, but yeah, definitely check your local municipality. So what are some of those local ordinances? We thought we might just identify what's going on in Denver. Denver is requiring a license to rent your unit out for short-term or long-term. So their definition of a short-term rental this is from their website. It's often facilitated by peer-to-peer websites such as VRBO and Airbnb. Their residential properties are available for rent for a period ranging from 1 to 29 days. pursuant to the Denver Revised Municipal Code, the city and county of Denver requires hosts to get a license in order to offer a short-term rental in their primary residence, meaning the place in which a person's habitation is fixed for the term of the license and is the person's usual place of return. A person can only have one primary residence. Summit County defines short-term rental as a short-term vacation rental property, as is defined as a residential dwelling unit or any room therein available for lease or exchange for a term of less than 30 consecutive days. And finally, I found one, Colorado Springs, the city of Colorado Springs, a residential dwelling unit or portion of such a unit that is rented for less than 30 days at a time, with the exception of dwelling units owned by the federal government, the state or the city, or any of their agencies or facilities licensed by the state as healthcare facilities. So I just wanted to demonstrate that this, as a lot of cities and towns have their own. It's not a cut and dry definition, but for the most part, I would say most cities identify short-term rentals as being less than 30 days, but there really is no definite definition, as you can see. The cost associated, Denver County is $100 a year. Summit County, there's different cost. You might have to do some research, but resort overlay zone, it's $265 a year. That means if your property is located in a resort overlay zone, then the cost for the license is $265 a year. Colorado Springs is $119 a year. All right, so, and then of course, we've been talking a little bit about short-term rentals, but there's also long-term rentals, and it's important to to know what you're dealing with. The Denver Revised Municipal Code, section 27-191, was recently updated. So there's two phases in the city of Denver for long-term rent. This is for the license that you have to buy. Phase 1 is effective on January 1st, 2023. And applies to a person offering, providing, or operating a residential rental property consisting of 2 or more dwelling units on a parcel under that person's ownership, and requires them to first obtain a license for that residential rental property. So that's phase 1. Phase 2, and you can look at, you can verify this information on the city of Denver's official website. Phase 2 is effective January 1st, 2024. It requires the same as the first phase, except a license is required for a residential rental property of a single dwelling unit. Check your local ordinances. A couple things to consider as you're looking into this is a license required to rent out your unit, or your homeowners? Do they need to get a license with their local authority? Does the unit have to be owner occupied? That you might have some restrictions in your governance policies, but generally that means the place in which a person's habitation is fixed for the term of the license and is the person's usual place of return. Is registration with the local government required? And then also you have tax considerations, tax implications. Do you owe local taxes for rental revenues? We have some frequently asked questions that we get. Can my HOA prohibit short-term rentals? Likely yes, but it requires on your it requires on your governing documents and any amendments that may be needed. Our HOA has short-term rental prohibitions in place. How do we make sure that we're enforcing them? Again, it can become a little tricky with House Bill 221137, but you got to make sure you're giving proper notice of violation. And you have to have a written policy or rules and regulations concerning the short-term rentals in order for you to issue a violation. Enforcements cannot, importantly, violations cannot be made arbitrarily or capriciously and should be enforced uniformly. That doesn't have to do with just rentals, but many different things in your community as well. So we kind of put together just a list of, some methods that we see that certain communities, how do they restrict rentals, or, what are they considering? One of the more popular methods is imposing a rental cap. in your community, that would be, you know, we as a board or we as an association agree that we're going to only allow, say, 20% of our units to allow rentals. That it's a little tricky to enforce because, you know, how are you going to tell whether a unit's being rented or not? But it's just a consideration to have a rental cap. You can also have lease restrictions, such as you can enforce a minimum 30-day lease. You can suggest to owners that they have their tenants acknowledge the basic rules and regulations of your HOA, such as quiet hours, trash removal, or the number of guests that are allowed on the in the property per, you know, at any given time. It might be a good idea just you know, if you're a landlord or if you're renting your unit out, just to have like maybe a brochure or a 3-ring binder sitting there on the coffee table when the renters come in. That way they're like, oh wow, look at the rule. Here are the rules and regulations of the HOA. Just a good thing to be informed. You know, we see rental registrations or signups with the association so that the association has contact information for the landlord and the tenant. I believe the city of Denver actually requires a contact person be made available at all times if the owner is out of town or not staying at their primary residence, as well as a list of city services that need to be made available. That way, if a renter has any concerns, they can contact the city for any emergency services. You can require that unit owners attest that they've provided a copy of the association's governing documents to tenants. And I do see occasionally tenant screening. You definitely need to be careful with that. You know, you want to be careful with fair housing laws and protected classes. You want to make sure that you're not preventing, you know, certain classes from applying or renting your property. So just a couple of considerations that your HOA might want to take a look at there. And so some pro tips, you know, board members and managers, review your local laws on rentals to understand what's required. Also, just regularly keep your community in the loop with what's going on with restrictions so that your homeowners understand what's permitted and what's not permitted. You can consider sharing this information by, you know, newsletter, mail, email, or a website if you have one. Just importantly, be transparent with the community. If you're a homeowner, if you're a landlord, share the declaration and the governing documents with your tenants, like I suggested. Also, if you rent out on a short-term basis, be considerate to your neighbors. Include basic rules like, you know, how many guests are allowed, no parties, no loud noises late into the night. Remember, if you're short-term or long-term, if the tenants are continually causing problems, your board or your neighbors can push to make a change to the rules and maybe even limit your rights to rent. So, you know, don't try not to spoil what might be a good thing for everyone, because rentals, they can provide like a nice supplemental source of income for some people. Yep, so here's our website. In case you don't know, we do have a website. It's dre.colorado.gov//HOA-center. We also have an email inbox, Dora_DRE_HOA inquiries @state.co.us. And then I wanted to open it up now just to some questions or that we can answer. Hopefully this is not what your unit will look like after you rent it out. That's just a little joke that we had, but yeah, we'd love to answer some questions in the chat that you might have. David or Amanda, do you see any questions in there?
I'm going to chime in. Casey Stark brought up a very useful website that I think that it's been around for some time here, but it's AirDNA. It's been pointed out to me a couple times as a helpful tool that people can kind of plug in some information and get an idea about what a property actually could theoretically rent for. And so it might be that might, for those of you that are in communities where rentals are permitted, of course, you are able to get at least that, maybe that will help give you an idea about what you might be looking at. Now, I don't know if AirDNA does short-term rental valuations as well, or if it's just for basically for the traditional monthly rental type situation, long-term rentals, but worthwhile resource for you guys to take a look at if you're interested. So I saw a question about if there was a penalty if you do not get the license. Now, I know, and I put a brief comment about this in the chat. There has actually been some news in the Denver market just recently. The Denver Post, 9 News, I believe, did a story about this as well. I believe Channel 7 did a news story about it as well. That Nick pointed out to me just yesterday, which is that the city of Denver is seeking to do some enforcement on this new rental license for long-term rentals. I believe that the story that I saw said that first offense is $150 and a second offense is $500, and I don't know what happens after that. So, the fees certainly can add up pretty substantially if you are not in compliance. Now, where we are currently with this ordinance, it shouldn't really apply to the vast majority of the attendees on this call because it pertains to individual landlords that are renting more than one parcel or more than one unit on a single parcel. What is going to be more important for the majority of you on this call is phase 2, which will take effect on January 1st of 2024, and that is and that's because that city ordinance then in Denver is going to start to take effect on single parcels. So if I have my condo or my single family house and I'm going to rent it, that would be a trigger for needing to have this new rental license. A question for you, Nick, is can an HOA restrict the number of leases issued for a property? I'm not entirely sure exactly what that means. If that means like if you can say, hey, you can rent it to X number of times on a short-term rental basis, or something to that extent, that might be what they're indicating. I have seen some limitations in associations, rules and regulations that talk about being able to rent out their property. I believe that the example that I came across was up in one of the ski towns in the mountains, where you were allowed to rent a certain number of times or a certain number of days. But there are also tax ramifications for you as a homeowner to consider as well. So you want to keep that in mind if you're renting out a unit a certain too much. Again, whether you want to talk to a tax professional or a licensed Colorado attorney would be a good idea there. Let's see.
Yeah, good point. I'm not sure to what extent a HOA can limit the number of leases that a homeowner might be able to contract into. I haven't really seen any examples of that, but it could be something worth considering. I mean, maybe you don't want your homeowners doing like 30 leases per year. That might be kind of crazy, right? Or it's definitely something worth considering if you want to have some kind of lease restriction in your HOA. Just trying to go through some of these questions in chat here. Amanda, did you see anything that you wanted to point out, or?
I do see a whole lot of questions that are coming in. I know it's amazing. You guys have so many questions. When I'm reading one, like 20 more come in. So you guys are so great at asking them. And I'm like, oh, great, it's lost. But no, I'm gonna go through them and look at a few questions. And if I see one that I definitely wanna read, I'll let you guys know. It looks like you guys are reading a lot of the good questions that are coming in. So thank you.
Yeah, I mean, there's one here, Micah, Micah had a question. Due to all of the issues surrounding short-term rentals, will state legislatures eventually mandate these property uses be regulated by the Real Estate Commission, similarly to long-term 30+ days or more triggering tenant landlord law? David, you might want to speak to that, but we're not quite sure. We're always we're trying to stay informed about what's going on downtown at the state capitol. But yeah, it certainly is kind of a hot button topic now with affordable housing and the homeless issues going on in Denver. So certainly I know there's probably quite a bit of activity going on right during this session.
Generally speaking, I can say that I'm not familiar with anything that is currently pending before the state legislature in that regard at the present time, and it's generally outside of our bailiwick to prognosticate on what might happen in the state capitol. But I certainly can say I'm not familiar with any current pending legislation or anything that has passed in the current legislation to that extent.
Fabian, let's see. Can an HOA board vote for an increase yearly fee that increases every year? My HOA charges an additional yearly fee for the folks who are short-term renters. HOA does not separate local residents who share couple guest rooms from non-owners occupied who rent the whole house, investor's house. So generally speaking, an HOA, there's no cap on the amounts that they can raise their dues. They can raise them as much as they need to meet operating requirements to run the community. But that might be something that you want to attend the next board meeting or next community meeting to suggest maybe we should cap the amount of fees for short-term renters, or maybe we should adopt a policy or a rule that says a renter has to stay in the primary residence or the investor's house. Only one bedroom can be rented out at a time. No, you can't rent out 3 bedrooms to 3 different renters, but only one renter at a time, if that makes sense. Let's see.
We do have that last question that we got from, I believe is it Deanna? Dina? I apologize. She's asking if her HOA can her HOA disapprove a unit's approval to lease if after approval of 1-year lease, the tenant purchases a property within 6 months, or the tenant gets evicted, or the tenant receives military transfer orders.
Dina, that's an excellent question. I'm going to take it in 2 parts. I think that you could certainly, there would be a fair argument to be made with respects to if the tenant were evicted or the tenant terminated the contract. I think the terms of that contract or of how the lease would be terminated would be an important one. But the second part of so it certainly, I could see it going either way if put before a judge in that situation. In the second situation, which would be military transfer orders, there are a lot of federally protected laws or federally protected rights that come from federal law with respects to military orders, and generally speaking, a lot of those laws are really two-way streets. They're initially designed, of course, to protect the military the military service person who has to be transferred or whatnot. But in this case, I could also certainly see a situation where a law like that would also could be construed to protect a landlord that would be affected by those military transfer orders as well. I would encourage the board to take that into consideration and look at the specific details of, well, did I evict a bad tenant, or did the tenant just leave, or did the tenant and the landlord reach an amicable resolution to terminate the lease preemptively before the end of the additional term, or the initial term, excuse me, something to that extent. So it would be something you'd want to definitely take into consideration, especially given that there are some of these things are as a result of the actions of the landlord. Other things would be the result of other parties, in some cases even the military. So keeping that in mind.
Yeah, I saw a question here from, there's a lot of questions. Somebody asked, how can we prove if our unit's being rented? That might be kind of difficult to prove right away, but what you could do is have the unit owner register with the board if you're allowing short-term rentals, just to provide basic contact information or information on maybe just the first name or something like that. You could just have the homeowners register or something to that extent. Let's see.
Oh, I did see, I apologize, someone has been raising their hand. Feel free to ask your questions in the chat. I believe his name is Donaciano. If you want to go ahead and chat your questions or ask your question in there, that'd be great. That way we can go ahead and read that off for you.
Yeah, I'm seeing here too, it's something interesting. You might require that a buyer or an investor or a new buyer live in that property for a certain number of years before they're allowed to rent it out. Advantages of that would be that owner would become more aware of the issues in the community, and they wouldn't basically just be snapping up all the properties just for investment purposes. So if you require that the owner live there for, say, a year, they might become more involved and care more about what happens to the property and the community if it were to be converted to a short-term rental.
So, Donaciano, I think, followed up with a statement that simply says that his community has a limitation of up to 4 units at a time in their community, and that one of the most common questions that they see, almost the first question that they see, is when receiving requests for information from mortgage companies, is whether or what the total number of rentals are. And again, going back to the FHA discussion that we had earlier, that is quite true. Those concerns are there. Private lenders certainly have more flexibility with respects to that, but FHA, VA loans, they are they do not have that same flexibility. If they see that you are renting above that, above whatever their cap is, they simply say, we cannot finance this purchase. And again, that goes back to one of the most important responsibilities of board members is to you act as fiduciaries on behalf of the association, on behalf of the community, and so you want to make sure that you have that you've taken these things into consideration, because if you are lowering the prospects of potential buyers from for the units within your community, you are arguably also lowering the purchase price that is available for people. So you want to keep that in mind, and especially if your community's governing documents discuss FHA financing or discuss these types of rental caps, you do need to follow through with those. You want to make sure that you have that you are in compliance as a board, and you are uniformly enforcing your the covenants and use restrictions, as well as your rules and regulations that are set forth in your governing documents. Candace is asking if a board can demand to see a copy of the rental agreement. Candace, our recommendation to you in that situation would be that, again, making the assumption that rentals are permitted in the first place in your community, that you promulgate or that you prepare some rules that include that as a requirement. As a board member, it's important, it's very important that you all know who's in your community, not only from a safety perspective, but also from a parking perspective. If you have someone come through and look at the license plates and say, "Oh, this person's not on the list or this license plate is not on the approved parkers list," what have you, you want to know who's there, so that you don't inadvertently tow someone that does have the right to be there because they've entered into a lease agreement with the landlord, the owner, the landlord. So obtaining a copy of that rental agreement is a very helpful step in that direction. Another very helpful step in that direction is to ensure that you have proper contact information for owners and tenants. If you, let's say I live in a condominium complex and I have to turn off the water for levels 4 through 10, I want to be able to notify, as a board member, I want to be able to notify every affected person, not just the owner, because the owner might live in another country. I always say Tahiti. They might live wherever they live. They could live down the street, they could live in another unit, but you want to be able to tell the tenant this information as well, so that they're not caught halfway through a shower when you cut the water off or when you cut the power off for whatever purpose. So collecting a copy of that rental agreement and collecting the updated contact information for tenants and owners is going to be a very helpful step.
Indeed, David. Let's see, is the rental license requirement for long-term rental phases applicable statewide? That I don't think there's any state mandated or like overarching state law, but each local municipality and city will have their own rental requirements.
Nick, if I could, we had a few other polls in here. I'd be very curious if I'm going to send one out to right now. I'm curious to see what people's perceptions are about the percentages of units that are rented within each of their respective communities. And of course, I know that that this is a more complicated question for an attorney or for a community association manager who's not necessarily representing one community here, but I'd be curious to see where some of these expected percentages are.
Yeah, it looks like results are coming in. Seems like we got about 75% who believe 0 to 24% of their units are rented. And about another 20% believe 25 to 49% of all units are rented. And then 6 or 7% think about 50 to 75%. So, I mean, that's certainly an interesting question. I mean, perception-wise. I think we had another poll too, David, that we were going to ask just generally what people's thoughts were on short-term rentals in general, whether they think their community should whether they think STRs would benefit their community or not. Look at that, a lot of no's. That's interesting.
And there was a request in the chat that to share these. I have been sharing them, but pretty briefly. So after we get a few more answers on the current poll, I'll post that the results for everyone to see just what those numbers really look like across the board. I think that's helpful for you to know about other communities in the state as well. And sharing. So in the case of whether or not you believe that short-term rental is a good thing for your community, I'd say pretty overwhelmingly, the impression is that they're not a real positive thing one way or another. And I think as Nick sort of said at the onset here, we're not here to take a position on it one way or another, but what we can do is we want to encourage each of your respective communities to think about the benefits and the pros and the cons of whether it's long-term or short-term rentals, and if you disagree with maybe what your association's doing now, we would encourage you to take some steps to make to generate some interest within your community. Talk to your neighbors, see what their thoughts are. Sure, there's going to be some yeses and some nos, but through that democratic process, even if you're not on the board yourself, you have the ability to affect change in your community. Make your case to your neighbors, and attend board meetings and talk to the board, and share your opinions there, and also if you're able to run for the board, where you have the ability to again represent the interests of your fellow community members in a positive way. Again, I think that there are lots of positives and lots of negatives, but no one situation fits all the communities in Colorado. We oftentimes talk about the tremendous diversity of communities in Colorado, and whether you're a ranch or a high rise, whether you're urban or rural, whether you're in a vacation town or somewhere else, all of those things are important considerations. Whether you've got a pool or not, and how do you enforce the rules around a pool or other amenities for individuals that may or may not be there for a shorter period of time, be it a few nights or a few months or a few years. These circumstances change from community to community. So really trying to look and talk with your neighbors in order to devise a situation that fits the characteristics of your community is a good way to do that.
Yeah, absolutely, David. Thank you. I would say we probably have another 5 minutes or so. If there are any other questions or comments that anyone wanted to leave. I just had a good, I was looking at some comments here. Donaciano had a pretty good comment regarding if you're thinking about allowing more short-term rentals, you want to be aware that as he says, as a board officer for our self-managed HOA, I frequently complete the paperwork requested by various mortgage companies, and I always note that their first question is about the total number of rentals. If we have too many renters, they will not approve the mortgage loans or the refinance of the condos. Our CCNRs clearly limit rentals to 4 units at one time. So yeah, that's pretty interesting. I mean, good thing to know that, you know, when lenders look at that, that's something that they'll take a look at. Amanda, anything else?
I am looking through these questions also. I did see a good one, and then a whole bunch of them popped up. You did read Lynn's. I was looking through one. Let me go ahead and find it, and I'll come back to you. And it was a really good one. I mean, we have a lot of good questions that are coming in. So again, thank you all for participating as much as you are.
I think there was a question here, you know, what do we do if we want to restrict, if our declaration was silent, what do we do? Like, what's the next step that we have to take? You would need to amend the declaration and put it to a vote in the community. You'd have to start that conversation with your neighbors and your board members. So it'd have to be put to a vote according to your declaration. And also, if it's silent, the board can still consider, as I had already mentioned, adopting rules that will abide by the local ordinances in play. So that's always a consideration, like noise or trash complaints. They still can't break government law. They still can't break the city law or city codes, even if your declaration might say otherwise. I mean, it's.
So I do see a question. This is from Linda. Can an HOA limit the number of unrelated tenants in one unit, and must this be contained in the CCNRs, or can it be included in the rules?
Sorry, Amanda, can you repeat that?
Of course. The question is, can an HOA limit the number of unrelated tenants in one unit, and must this be contained in the CCNRs, or can it be included in the rules?
There's a couple important considerations when you're looking into that in answer to that question. Primarily, it's going to come down to fair housing laws, both federal, state, and in some cases, local fair housing laws. Unrelated parties may not necessarily be unrelated. It is, as it's against several of these laws, to discriminate against marital status, to discriminate against familial status. And so there are lots of difficult questions that arise from that. Traditionally, a community, if you are renting out maybe an accessory dwelling unit, an ADU, that certainly might change the calculus to a certain extent, because there you're not necessarily under the same roof per se, as an ADU is usually a separate unit that's somewhere on the same parcel of land, like above the garage or what have you. So those are some important considerations to take to heart there, and to be very mindful of. And in the case of a board, if you're looking to go after or enforce a rule of that sort, you might want to first consult with counsel to determine whether or not you're butting up against any or crossing the line with respects to any discriminatory practices or other fair housing laws.
Thank you, David. So I just wanted to thank everyone again one more time for joining us today. This has been a presentation on rental restrictions in your community. I think we're gonna wrap it up here and say our goodbyes. But again, my name is Nick Altmann. I'm the HOA Information Officer here with the Colorado Division of Real Estate. And David Donnelly was also with us today. He's the Communication and Education Policy Manager with the Division of Real Estate. And also thank you again to Amanda Lopez as well. She's our registration specialist. So again, thanks for joining us. We are going to have another HOA forum in March next month on metro special districts. So that should be very interesting, and also a very another hot button topic. But again, thank you very much. And we're gonna bid our farewells. And I hope you have a great rest of your weekend. Thank you very much for joining us today.